You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Assalamu alaikum everybody, welcome to the Ask a Lawyer show. I'm your host Attiq Malik, Director of Liberty Law Solicitors, and your host for today's Know Your Rights Toolkit show. It's been a little while since I've been here. A lot of people have been away over the summer break. I was away for a little bit myself. And of course, you've been hearing from other members of our team who've been coming in and doing shows on different topics. And so I thought, we're back to school now, back to work, and what better way to kickstart it all than to come back here myself and to do a quick Toolkit show. And the Toolkit show is a one-on-one show between myself and the listeners. It's a live show, so you can call in, text in, email in. Actually, I don't know if you can email in, but you can message in on social media with the tag at inspirefm.org. You can call or WhatsApp in on 07779 481822 and 07779 481822. That's for messaging. And to call into the studio, it's 01582 481822. That's 01582 481822. So, make it your own. I'm going to be talking about knowing your rights, and with knowing your rights, in the past, the Know Your Rights show has mostly been about knowing your rights in the criminal arena, when you're arrested at a police station or getting booked in or the police are talking to you. But I thought, let's talk about your rights in an employment arena too, as employees. What are your rights at work? And what is the difference between the rights an employee has to the rights that a contractor has? And then you have this vague in-between bit of a worker. What rights does a worker have? So those are the three categories of people that we see in the arena of employment law. And so we're going to discuss that today. Know your rights in the context of employment. And when we discuss knowing your rights in the context of employment, this topic isn't just of interest to employees and people who work for organizations, but it's also of interest to those who own and run organizations, because as a business owner, you need to be aware of what rights your employees have. Because if you are not aware and you conduct your business in such a way that it breaches, impinges, contravenes, whatever word you wish to use, the rights of your staff, then you open yourself up to litigation, you open yourself up to complaints to employment tribunals. And the fact of the matter is this: no matter how much money you might have as a business, or how good a relationship you have with your staff, you need to have systems in place which protect you, because you've got better things to do than to be dealing with complaints and going to court for cases such as in the civil courts or the employment tribunals. And therefore, having proper policies and procedures in place is extremely helpful for all businesses, and knowing what your employees' rights are to ensure that you don't accidentally breach their rights in any way. Now, the fact of the matter is this: if you do a topic on employment law on knowing your rights, it's such a broad category that you could spend not just hours but days talking about it, because the whole of employment law is effectively the rights that employees have. So if you go across the board of every piece of legislation which applies to employment law, 90% of it would translate into the rights for employees. And so within an hour that we have, we would have to strip it down to just some of the key headline points. And so on that note, if any of you out there have any queries about employment law, just call in. Feel free to call in on 01582 481822. That's 01582 481822. You can also message in, contact us on social media, and the tag is Inspire FM Luton, I believe it is, for the social media tags. And some of you might find it quite personal, even though we can anonymise who's calling or messaging in. you still might find it quite personal to be able to speak on the airways or message in about your problems. And so if that's the case, feel free to contact the studio or myself directly at Liberty Law Solicitors with any questions or concerns that you might have. And we'll do our best to try and help you and assist you and answer those questions for you. So, what are the main rights that employees have? Now, a lot of the rights that employees have, such as the contractual rights, the right, for example, one of the mostly used and known rights, the right to not to be unfairly dismissed, the right to have your wages paid to you on time, the right to have holiday pay, the right to notice pay, the right to a work colleague or trade union representative, for example, to attend with you at meetings. All of these rights and many more are enshrined in the Employment Rights Act of 1996. Now, there are a lot of other rights which are not in there, but tie into it. So, for example, you have the right not to be discriminated against. Now, whether or not you have been discriminated against, all of that arises from, and the right not to be discriminated against arises from the Equality Act of 2010. A lot of employees are protected by the 2P regulations, for example. 2P regulation stands for Transfer, Undertaking and Protection of Employment, Protection of Employees regulations, and that is a separate piece of legislation that protects employees who are moving from one company to another, or someone who's working in a company and the department they're working in is then outsourced to another organisation. That all falls under the heading of 2P. And so in that situation where your work is being moved from one place to another, such as from one company to another, because let me give you an example. Cleaners are a very good example. Someone works for a cleaning company. Via that cleaning company, they work at a school on a regular basis and only at that school. The cleaning company then loses the contract for the work at that school to another cleaning company. What happens then is 2P kicks in, because if the work has moved off to another company, there's an argument that not only has the work moved, but the role attached to that work has also moved. And so it's a very complex area of law, but effectively the purpose of it is to protect employees who could otherwise lose their jobs because the project or the work that they are normally focused on is no longer being done by the company they're employed by, but by a different company. And so to preserve the employment rights of those employees, to preserve their continuity of employment, to preserve their livelihood, 2P regulations were drafted and implemented so that employees would still have rights. And 2P in itself, I think, is an amazing piece of legislation which a lot of people don't really understand. And one of my favourite points of 2P over the years when I first came across it was the amount of power it can give to an employee that otherwise on the face of it you would think is in a very weak position. For example, under the law of 2P, if your employment contract, and it's known as being 2P'd across, so another company takes over the work that you work on. This could happen in the IT sector. You could work for a company in the IT department, for example. The company then decides to outsource all IT work to a third-party company and make you redundant. But what in actual fact is happening, because your work's moving from one company to another, you could argue that what's actually happening is a 2P transfer of your employment from one place to another. And what employers could do, and we've done this in the past, is if the person is dismissed because of what should have been a 2P transfer, that person can bring a claim for unfair dismissal, because if your termination is as a consequence of a 2P transfer or linked to it in any way, then potentially under employment law, under 2P legislation, that can form what's known as an automatic unfair dismissal. And in that situation, you can not only potentially then bring a claim against the company that terminates you. So let's say company 1 is who you're working for, and then company 2 is where the work's gone to, and then what company one has said is, well, we no longer have that contract for IT or for cleaning or whatever it is, so we're going to make you redundant. The employee who's been made redundant could argue, actually, no, you shouldn't have sacked me, and bring a claim against the first company for dismissal on the basis of unfair dismissal, because you sacked me because of this 2P transfer that was going to happen at the future date. So you sacked me before then, and that's wrong. I should have been kept employed until the contract end date and then moved across. And then what they could do is present themselves as company number two and say, hello, company number two. I used to work on this contract that you've now taken over, and because I was working on there, you need to give me a job. Now, company number two might think, oh my God, we've got no space to put this person because we've already got full staff for this project. And in that situation, either company number two is forced to give that person a job. If they do, their employment is safeguarded, their livelihood carries on. Or they would have to give them some sort of a package under a settlement agreement. Now, some of you may ask, well, what is a settlement agreement? A settlement agreement is a waiver of legal rights to sue a company in employment law. So what it means is, when an employee enters a settlement agreement, they are agreeing not to sue the company. They're waiving all legal rights once they sign that. But of course, you wouldn't just waive away your legal rights to sign somebody, to sue somebody. You would only do it if you're getting something in return. And so often people who are in a redundancy situation, where they're being made redundant from a company, and then figure out actually there's a 2P transfer taking place, and what the companies are doing is letting go of old employees just before the 2P transfer, so that the new company doesn't have to have their weight in terms of liability, etc., and of the old employees coming to them. They can then get a settlement agreement or redundancy package from the first company when they terminate them, because they're being made with speech marks redundant. But then on the second company, they can, if the second company does not take them on, they can say, well, I want a settlement agreement too. And so quite often we've had a situation where people have come to us with their settlement agreements or the redundancy situation, and not only have we achieved a negotiated on that package to get them a good package for the initial settlement agreement, but we've then been able to go to company number two and get a second settlement agreement, so second payment of money and other items under the settlement agreement. So they, in effect, at the very least, double up on what they started off with. In terms of a package from the employer, because they're getting two packages from two employers. And the reason you're getting a second package is under a promise from you, the employee, that you will not bring a claim for unfair dismissal against the employer. Now, in some cases, it might be the case that there is no claim, but even a rubbish claim or case with no strength has what's called a nuisance value. And a nuisance value still costs a business money, because even if someone's got a rubbish case, to defend a rubbish case and to respond to it still costs time, still costs stress, still costs money. And so even a nuisance value claim has some value to it, which might trigger a business to think, actually, I've got better things to do with my time rather than to argue this or fight this or take this to court. And therefore, let's have a settlement agreement. Let's have a clean break, like a divorce between a husband and a wife. Let's sign this off, let them have their way, have a little bit in their pocket, walk away, and we go our way, clean break, no further issues, and peace of mind for us. This person isn't going to come back to us in a few months' time or years' time and try and sue us for something, even if there's no claim there. And of course, if there is a claim there, then it's even more of a reason why a company would consider going into a settlement agreement and by using that mechanism to end a relationship with a current or former or prospective employee. Now, in that situation, as the example that I gave, you will know that there were two options open to the company: either to give a settlement agreement and get rid of the person, or to get that person to or to get that person to come in and agree and work with them as an employee. Now, let's just explore that situation a little bit further. And just to reiterate again, in case anybody new has just tuned in. So person number one has just been terminated, dismissed from their employment because the worker moved to company number two. They come over to company number 2, so the employment is transferred, and it's known as a 2P transfer. They're 2P'd across from one company to another because the work has moved from one company to another. When they arrive at the new company, you will find that the employee had one contract of employment and contractual terms from the old company. And quite often they might be presented with different contractual terms with the new company. So then the question is, which contract of employment is in place? Which contract of employment is in force and has legal power? Now, under 2P, the starting position is always that the employee who's being 2P'd across, the original contract of employment stays in place, and that the employer cannot force another contract of employment on them. Now, this is where a very powerful position now arises for an employee, because what an employee can then do is this. Imagine the employee has got an absolutely amazing contract of employment in their current role. The role moves across to another company and they transfer across with it. In the new company, the IT guys there or the cleaning people there all have so the IT people there and the cleaning people there have got a contract of employment in place which is not as beneficial as that of the person that's just come across. Examples of not being as beneficial could be the salary. They could be on a lower salary. They could have a lower notice period. There could be contractual benefits that the employee has which the other company doesn't normally give to their employees. I don't know, such as company car, mobile phone, laptop, healthcare. There's a number of different things that there could be. So what happens to that then? Well, under 2P, the employer has to honour the initial contract of employment that the original contract of employment that the person had before they 2P'd over. But what happens then if that employee thinks, you know what, my contract does have better wages, it has a better notice period, I can get a better laptop, for example, or a phone or something. But the concern that I have, though, is the employees here, they've got better holidays than me. I only get 25 holidays a year plus bank holidays, but these employees in this new company, they get 35 holidays a year, for example, plus bank holidays. That's absolutely amazing. What happens then? What if the employee wants to have the holidays but wants to keep his current salary? Does he have to choose between the two contracts? Well, no. Under 2P, this is where the real power comes in now. The employee coming across can actually choose if there are any terms from the new contract they want to adopt while still retaining the original contract. So they can effectively have the best of both worlds. They can say, well, okay, I'm keeping my high salary, I'm keeping my good notice period, I'm keeping my other contractual benefits, healthcare or whatever it is, but see that holiday that your employees have? I want that too. And so for that reason, an employee who's been 2P'd across can be a big burden sometimes on a new company. Similarly, the other burden that transferring employees can bring with them to a new company is liabilities. So let's say, for example, there's an employee and that employee has been involved in something with another employee, such as an act of discrimination, harassment or bullying, and another employee has now brought a claim against this employee. Because this employee has transferred across under 2P, you inherit the liabilities of that employee too. And so if that employee then gets sued for discrimination, on the claim form, not only would there be the employee's detail, the employee's detail, that's right, who has done this act, but also their employer. And so often you could end up facing a claim for something you had no knowledge about and had no responsibility for. And so that's another danger of 2P. In order to protect themselves against this, what businesses often do then is they do two things. One is under is a legal requirement where businesses should give a transfer. You have a transferor and a transferee, and where the transferor gives to the transferee a list of liabilities setting out all the employees and any grievances that they might have against them or from them, as well as any other sort of issues such as tribunal issues. Now, to protect the business that is being transferred to, it's often a good idea to get an indemnity from the first company to the second company, saying that if any losses or actions or liabilities arise from the transferring employees, that they will indemnify them against those losses. And the advantage of that then is, if that indemnity is in place, that when the transfer takes place, if then at that stage the second company wishes to so has an issue where someone sues them because of the difficulties arising from one or two of the employees that have transferred across, and they suffer a financial penalty because of that, they can then recover that money from company number one, who's entered into an indemnity with them. And so again, you can see there is it's quite a complex area of law, but the legal rights, going back to a topic that we're discussing today, knowing your rights, is quite an important topic, I'd say, to know, because often we are approached by people going through settlement agreements and redundancy procedures, and they're on a real downer because they think that they've been made redundant and they have no option. And then when we identify, actually, this is a 2P transfer here, and not only can you ask for more money and a better package from your current employer who's dismissing you, you could potentially get a second settlement agreement and therefore a second payout from this other company. It changes things a lot. And it's amazing out there how many people don't know about this or how it works. And the best bit is local authorities. I mean, so often we get local authority employees, and the general perception of local authorities in the public out there is they know what they're doing and all the rest of it. But my God, the amount of times we've litigated against local authorities around the country, and the amount of times they've overlooked issues such as 2P, and then they had to pay out twice, is absolutely amazing, So do not think, my employer is so professional, such a big employer, they're not going to make a mistake, they would have picked this up. Actually, you'd be surprised at how many mistakes companies make and how easy it can be sometimes to catch an organisation out, and therefore you should always get proper legal advice. Now that takes us into the way settlement takes place as well, because we all know of an organisation called ACAS. ACAS is a free mediation body. It's government funded. Now, ACAS can also be contacted to help diffuse matters between employer and employee, and an ACAS agreement known as a COT-free agreement, a settlement agreement, basically is legally binding. So often when people want to save money, they might come to an agreement between the employer or employee, do it through ACAS, and get ACAS to draft the agreement and just sign it off. Now that has a pro and a con to it. The pro to it is that even if an agreement is discussed over the phone with ACAS and the agreement isn't actually signed, the minute they discuss it and make an agreement over the phone, the parties do that, it becomes a legally binding agreement. So that's a special power that ACAS have. Further to that, it's a free service. It doesn't cost the employer or the employee any money, as well as the fact that it's legally binding. Now, the problem with ACAS is this, that with ACAS, they are not legally qualified, okay? They may be able to draft a very basic agreement, but some situations require a more complex agreement to be in place, either to protect the business or the employee or both. And sometimes the package might be such that you need to cover a lot of different things, and in those circumstances it's always better to get the lawyers involved and get them to draft a settlement agreement. In that situation, whilst it's a bit more costly for the business, you would not get a thorough settlement agreement drafted by ACAS as you would get by a lawyer for a business, firstly. Secondly, from the employee's perspective, if the business gets their lawyers to draft a settlement agreement, the settlement agreement is not legally binding until you have a lawyer of your own independently advise you on the terms of the whole agreement and sign it off for you. Now, Of course, no lawyer is going to work for free, but it's industry practice that the employer would pay for the legal advice that the employee receives for the settlement agreement to encourage the settlement agreement to be advised upon accordingly and finalised. And so what that means in the short terms for normal people is if your employer gets their lawyers to draft a settlement agreement for you to get advice on from an independent lawyer, it won't cost you anything because they are paying for it. And from an employer's perspective, even though they are paying for it, it's more expensive than going to ACAS, it's better because you get a more bulletproof and more comprehensive settlement agreement covering you and protecting you from every single angle than you would from ACAS, because their templates and their agreements are much more basic and broad brush, because of course we're not lawyers, we're not legally advised, no matter how much training they receive. So that's in a nutshell the first part of our Know Your Rights program. We've come to the end of the first part of the show. Listeners, feel free to call and use this opportunity to speak to myself, even if it's on a different topic that we're not discussing today, because at least you can have a quick chat. And this is a live show, so make this your own show. If it's something specific you wish to discuss, let us know. 01582 481822. See you after the break. Assalamu alaikum.
Assalamu alaikum, this is Atif Nawaz. Listen to Inspire FM shows in your time by heading over to inspirefm.org or listen on Apple Podcasts or Spotify.
Attiq Malik, Liberty Law Solicitors, here today discussing Know Your Rights in the employment law context. This is a Toolkit show hosted by me, which means there are no panel guests in the room today. It's just me, myself in the studio alone, speaking to you directly, the listeners. And it's an opportunity for you to contact me directly and engage with me about any questions or concerns that you might have. You can call in on this live show on 01582 481822. That's 01582 481822. You can also message in on 07779 481822. That's 07779 481822. You could also WhatsApp on that same number. Email at info@inspirefm.org. And also, of course, on social media, we should be live right now on Facebook Live. And you can contact us on Inspire FM Luton on Facebook and engage with us from that way as well. So, the first part of the show, I just give a little taster of rights, and what we established was that in the employment law context, your rights are essentially all the different pieces of legislation in employment law. Ultimately they add up to employment rights. And so, unlike criminal law toolkit shows that we've done, it's almost impossible to discuss the whole of employment law in 1 hour. But what I will do is go through some headlines. And in those headlines, we discussed the Employment Rights Act. We discussed, very briefly, we touched on the Equality Act. And then we went into the 2P and 2P transfers and the legal rights and powers that employees have from that. Now, going back now, into the basic rights. What is a basic right? Let's start from the basics. Employment Rights Act sets out the basic rights that employees have. So, first of all, the most basic right is the right to a statement of terms. Now, what does that mean? Often, employees are of the view that they have a legal right to a contract of employment. In actual fact, that's sort of right and sort of wrong. You don't actually have a legal right to a contract of employment. So if a business employer failed to give the employees a contract of employment, provided they have given something in writing which amounts to a statement of terms, they do not have to have given a contract of employment. To satisfy the statement of terms requirement, they can actually give you something which is less than a contract of employment. So an example of that would be this. Employee starts working with an employer. The employer sends out an email setting out the person's job title, start date, salary, holiday entitlement, notice requirements, and a few other basic pieces of information relating to the job they're doing. And there's an argument there that that basic document amounts to a statement of terms. Statements setting out the terms on which you are engaged. And therefore, even that basic document, if that satisfies it, means the employee would not have a claim for failure to provide statement of terms. So that's what it actually is, actual terminology and what it means. Right? Now, as far as a contract of employment is concerned, whilst it's not a legal requirement to give a full, detailed, substantive contract, it's best practice, because if a business gives a contract of employment to an employee, you know, number one, that you have satisfied the legal requirement for statement of terms, because the contract of employment would contain, of course, within it, the person's name, job title, start date, job role, duties, salary, notice period, entitlement, holiday pay entitlement, any other sort of entitlements and procedures, or at least touching on them. And so, number one, you know you've met the legal requirement for that, namely the requirement to provide a statement of terms. But then going beyond that, it establishes the basis of the relationship between the two parties. So if there's an issue later on, you have a document to refer back to. So if an employee didn't do their job properly or did something wrong, you can go back to a contract of employment and say, listen, or look here, this is what we agreed to. This is the terms on which we are working. You are not complying with paragraph this or paragraph that of the contract. Therefore, you are acting in breach of contract, and therefore I'm going to have to discipline you or get rid of you. So for those sorts of examples, the contract of employment is very useful. It also sets out the framework for the employer and employee to understand what is the basis of their relationship. So similarly, if an employee is expecting a certain amount of holiday and we do not receive it, they would bring that to the attention of the employer by reference to the contract to say to the employer, excuse me, as you can see, I should have received, for example, 20 days of holiday this year. You've only given me 10. All my wages state in my contract, they will be calculated in this way, paid at this, in this way, or in this frequency, or bonus is calculated in this way and paid in this frequency, and therefore, as far as I'm concerned, you have breached my contract of employment. And then having that in writing crystallizes the relationship, crystallizes the rights the employee has, and also what responsibilities the employer owes, and vice versa. When I say vice versa, what that means is it's a two-way street. It also applies backwards. So, for example, if you have a contract of employment which sets out what the duties are that the employee has to do, and the employee does not comply with those duties, then the employer can sanction the employee by way of disciplinary processes, or even terminate employment on the basis that employees fail to honour their end of the agreements of the bargain, that is to do a certain amount of work or a certain type of work in a certain way. So the contract of employment is just that. It's an agreement between two parties. That's what contract means. It's an agreement between two parties to do something. Employer agrees to give the person money in return for them performing a job. Employee knows that they are going to get money for doing that job, and then around that core principle, you have other legal rights which are agreed to. So you have a legal right, for example, holiday, and then the contract of employment spells out precisely what amount of holiday. You have a legal right to say notice pay on termination or notice of termination. Contract employment will specify what that is. Is it the statutory minimum of 1 week for each year of service, or is it more than that? Some people, for example, especially people working in senior management positions, might have 6 months notice entitlements or a year's notice. And then you move into the other entitlements which you would not normally be entitled to, but the contract of employment gives you that entitlement. So an example of that is this: laptops, for example, or mobile phones, or healthcare. These are not legal entitlements. You're not legally entitled to a work laptop or a mobile phone or healthcare. But if your contract of employment provides for that, it then becomes a contractual entitlement, and therefore in that situation you can demand that from your employer. Another example of contractual entitlements versus statutory entitlements. Statutory means the legal minimum that this country has to provide. And I've already given an example of notice pay, but another very good one is redundancy pay. If the contract of employment or related documents are silent on redundancy pay and you're made redundant, you're entitled to statutory redundancy pay, which works out at a maximum of circa £480, £500 for each year of service, and then you have a multiplier based on your age. Now, if you have a contractual enhanced redundancy pay, you can demand more. So some people have amazing contractual redundancy entitlements, where for each year of service they get a month's wages. And in that situation, someone who had 12 years service gets 12 months wages. That's a year's salary. You would not get that if there was a statutory entitlement for redundancy, for example. And so that's another example where you have statutory minimum entitlements that everyone has as a legal right, but then the contractual entitlements can not only match the statutory minimum, but they can exceed those. So when one's examining, considering rights in the workplace, you have to look at two sources for that. And this is what we examine when we see employees. We are always examining, we have two categories to consider. One is the statutory minimum, which is triggered by the person's role and length of service more than often. But on top of that, we also look at the contractual entitlement in case there are any enhanced rights under the contract of employment, which the employee is entitled to and may not even be aware of. And so these are the two sources: the law, which is statute, and the contract of employment itself. So we always have to examine these when we're trying to understand what are our rights in the contracts of employment. Now, there are certain rights which do not need to be written down in a contract of employment to be applicable, and one of those is, of course, the right not to be discriminated against. And now discrimination is a very wide piece of legislation, because there are different types of discrimination. Now, often when we're approached by employees and they have a case, often we are taking instruction and they will say something along the lines of, I feel like I'm being discriminated against, I'm being picked on, I'm being victimized. Now, a jargon like that needs to be refined and understood to make sure that both parties are on the same page. So if an employee says that to me, the first question I will always ask him, well, why do you believe you're being victimized? The employee will say, oh, it's because I'm being singled out and picked on. Now, we've said this before in previous Toolkit shows, that is not the definition of victimization. In the employment law context, the definition of victimization is where you are singled out and treated badly because you have submitted a complaint of discrimination. So if you have not submitted a complaint of discrimination and you are treated badly, then you will not have a claim for victimization. It's as simple as that. Okay, so no complaint resulting in bad treatment, no claim for victimization. Okay, so then we go back into discrimination law. What is discrimination and how do we understand it? Now, discrimination is this, and this is, I'm going to just set it out as basic as I can. Under the Equality Act 2010, discrimination occurs where a person suffers unfavourable, less favourable treatment because of a protected characteristic. Now that's very important, because often we have people who approach us and say, I feel like I've been discriminated against. And we ask the question of, why do you feel been discriminated against? And they say, oh, this person's treating me really badly, the way they speak to me, or the way they haven't promoted me, or the way they haven't given me a pay rise. So then we ask, okay, but why is that? Now, if the answer to that is due to personal dislike, or the answer to that is because there is a dispute over your performance, you think you're performing really well, and the business believes that you're not, right? Then in that situation, the issue you have is neither of those examples amount to discrimination. And the reason for that is this. You're only discriminated against if the adverse treatment that you're complaining about is because of a protected characteristic. So if you're being bullied because someone just doesn't like you as a person, or you're being skipped for pay rises, or you're dismissed because of your performance, and not because of a protected characteristic, then you do not have a claim for discrimination. So the next question then, of course, is what is a protected characteristic? In the Equality Act 2010, you have a list of what is a protected characteristic, and this includes items such as race, religion, sex, sexual orientation, disability, age. Now, what that means then is if you are being treated badly, and the reason for which you're being treated badly is not because of your race, it's not because of your age, not because of your religion or your disability or your sex or your sexual orientation. But in that situation, you are not suffering discrimination. You have to be treated badly because of one of those reasons to be able to complain that the conduct amounts to discrimination. Okay? And so as such, as far as that's concerned, discrimination has to be linked back to that. So if you are bullied because you're a woman, or because you're a Muslim, or because you're black or brown or anything like that, or because you are of a certain sexual orientation, or even if you're not, but people perceive or they think you are, then you have a claim there potentially. Another type of claim, now we get into the complicated part of discrimination law, is what's known as associated discrimination. So, I'll give you an example of this. You are not treated badly because of your protected characteristic, but because of the consequence of your association with somebody who has a protected characteristic. So, let's say, for example, you do not suffer from a disability, but you have a close family member that does. Because of that close family member that suffers from a disability, you have certain commitments and responsibilities that you have to work around. So, for example, you cannot work certain hours because of your care commitments of that disabled person, or you cannot do certain job roles or go to certain places because of those care commitments. If you are then sanctioned because of that, and dismissed or punished in any way, or not given opportunities as other people are. But even though you are not the one who's suffering from that protected characteristic, namely disability, you could still bring a claim for that and argue that you suffered a detriment which is discriminatory, because you would argue that you were discriminated by association. So by association with a disabled person, as a consequence of that, and what comes out of that in terms of responsibilities and commitments, you are then being sanctioned and therefore suffered less favourable treatment. You suffered a detriment which is unfair and unlawful. So that's another way you can bring that in. Also, in discrimination law, you have what's known as direct and indirect discrimination. So what that means is this. Direct discrimination is where you yourself are being discriminated against because of your protected characteristics. So, for example, I'm just going to give an extreme example. You're dismissed because you're a man. Okay, let's just say that happened, or because you're a Muslim, or because you're black, or you're brown, or whatever. So you could bring a claim for that. That's direct discrimination. But what is indirect discrimination? Indirect discrimination is where there's a practice, criterion or provision in place, policy criterion provision in place that the company has, which, when it takes effect, has a adverse effect on a group of people because of their protected characteristic. So let's have an example of that. For example, a company has a policy that everybody who works for them has to work on a full-time basis and has to work certain fixed hours. The effect of that is that women with childcare responsibilities cannot work in that role because they can only work part-time. or they can only work certain hours. Okay, as a consequence of that, they are suffering a penalty or less favorable treatment because they are not able to secure that job role, or if they are in that job role, they cannot maintain that job role because of their childcare commitments. And sometimes that can arise out of a maternity or where a person is working full time, then goes on maternity, has a child, comes back, but cannot work the same hours or same frequency as it did before because of the childcare commitments. And the company has a policy that to work in that job role, you have to work certain hours or certain timings. That policy then is potentially discriminatory on an indirect basis, because whilst nobody is specifically targeting that employee, there's a general policy in place which puts people from that category, which is a protected characteristics, at a disadvantage. And so that's an example of indirect discrimination. So we have direct and indirect discrimination. Victimization we've already covered. And then you also have bullying and harassment. Now, harassment under discrimination law is quite interesting in employment law. Ordinarily, if you bring a claim for harassment, you'd have to bring it under the Protection from Harassment Act 1997. Section 3, I think it is. And the way that works is you have to show that you've suffered treatment which amounts to harassment on 2 or more occasions. Now, the interesting thing about discrimination is if you're bringing a case of harassment under discrimination law, so where you're being harassed, and the definition for the word harassment is unwanted conduct. Yeah, if you're suffering unwanted conduct that causes you alarm, distress, there's a few other things it causes, my mind's going blank, but in a nutshell, you're suffering conduct which amounts to harassment because of a protected characteristic, such as because of your sex or sexual harassment or race or religion. You can bring a claim for that, even if it's happened on one occasion. You don't have to have at least 2 occasions as an example. So the law of harassment and discrimination law from that aspect is a bit more easier to engage with and bring a claim under. And also it's in the employment tribunal system, because the Protection of Harassment Act 1997 claims you have to bring in the county courts. You cannot bring them in the employment tribunal, and therefore a claim in the employment tribunal, the advantage of that is there's a non-fee regime, so it doesn't cost you anything to issue a claim in the employment tribunal, whereas in the county courts there are fees for everything. There's an issuing fee for issuing a claim, there's a hearing fee, there's an application fee every time you wish to make an application, and so there's a lot of fees to consider, and processes are different compared to the tribunal system. But the difference between the two, though, of course, is time limits as well, because in employment law, if you bring a claim, you have to bring it within 3 months minus 1 day of the act in question, whereas Protection from Harassment Act claims, I believe you have 2 years. So that's an advantage as well. The other matter is that with the discrimination claims, you have to show that the harassment, the unwanted conduct, is because of a protected characteristic. So, for example, if you feel because of a disability you're being harassed at work, if you bring a claim under the discrimination legislation, you'd have to also prove that you suffer from a disability. If that point was disputed and you could not prove that you suffer from disability, your harassment under the grounds of disability claim would fail. Whereas under Protection from Harassment 1997, you don't need to prove that it's because of your protected characteristic. All you need to prove is that you suffered unwanted conduct which amounts to harassment. So both have different advantages and disadvantages, and it's always a matter of sort of weighing it up in terms of evidence and what is the stronger and better way to proceed when one considers what claim to bring. But it's interesting how in employment law, though, in employment tribunal system, there is no freestanding claim of bullying and harassment. So if you've been suffering bullying and harassment at work and you want to bring a claim in the employment tribunal, unless it is linked to a protected characteristic, such as age, race, sex, disability, religion, sex, sexual orientation, you would not be able to bring a claim. However, you can bring a claim in the county court for harassment at work under the Protection from Harassment 997. And just to sort of open this up a bit more, for everyone out there, the Protection from Harassment Act 997 covers all situations. It's not limited to just the workplace. That's just one example. So there's been, I believe, examples in the place where in-laws, where I think wives have brought claims against their in-laws for harassment under the Protection from Harassment Act. I remember many years ago when this legislation first came out, there was an amazing case where a lady was getting repeated debt collection chaser letters from a utility company, and she brought a claim against the company under Protection from Harassment 997 because she said that the sheer volume of letters that were coming in and the frequency with which they were coming in were beyond what was proportionate and reasonable in the circumstances, and therefore amounted to harassment. So it's quite an interesting piece of legislation. The Protection of Harassment 997 is, I have to say, and it might sound nerdy, is one of my favourite pieces of legislation because it's such an adaptable piece of legislation which covers so many different circumstances. You can actually be quite imaginative about it in terms of deploying that. And then the other thing that legislation also has is criminality. There's a lot of claims of harassment in the criminal arena, but they rely on the Protection from Harassment 997 to prosecute. So you can prosecute somebody in both the criminal and the civil arena using that one piece of legislation, that is the Protection from Harassment Act 1997. Right, unfortunately we've come to the end of this Toolkit show. Thank you very much for listening in, everybody, and if you have any suggestions for any future shows, please feel free to contact myself either through the studio here at Inspire FM or directly at Liberty Law Solicitors. In the meantime, please, I hope everybody has an amazing week, and we look forward to the next Ask Your Lawyer show next week. Assalamu alaikum, and wishing everybody all the best for this evening.
Thank you for listening to our podcast. Why not tune in to our live stream at inspirefm.org and follow and subscribe to our social media platforms at Inspire FM Luton.